And it is not a good day for civil liberties advocates either. A federal appeals court threw out a lawsuit that would have prevented the U.S. from indefinitely detaining people under the National Defense Authorization Act. The Second Circuit Court of Appeals found that the group of lawyers, journalists, and activists who brought a lawsuit against the Obama administration cannot mount a case, saying they, quote, lack standing because Section 1021 says nothing at all about the president's authority to detain American citizens. The non-citizen plaintiffs also failed to establish standing because they have not shown a sufficient threat that the government will detain them under Section 1021. So the group maintains that the NDAA, which, by the way, was re-upped in 2012, is unconstitutional, and it could possibly lead to the arrest of innocent Americans. They are now looking to the Supreme Court for a final verdict. For more, I'm joined now by Tangerine Bolen. She's the founder and director of Revolution Truth and also a plaintiff in this NDAA case. Hi there, Tangerine. So let's start off by talking about this ruling. How far back does it put your cause, in your opinion?
Well, the fight's not over. We have plenty more to try with this case, but, you know, it's disappointing, it's frustrating, it's a bit exhausting. So just from a personal standpoint and from our team's standpoint, it's unfortunate, but, you know, the fight's not over.
Now, journalist Chris Hedges was particularly disappointed in this ruling. In a statement that he released to Truthdig, he said, quote, "It means there is no recourse now either within the executive, legislative, or judicial branches of the government to halt the steady assault on our civil liberties and most basic constitutional rights. It means that the state can use the military, overturning over 2 centuries of domestic law, to use troops on the streets to seize U.S. citizens, strip them of due process, and hold them indefinitely in military detention centers." Now, your group argues that the indefinite detention clause has a unique effect on journalists. Can you explain that a little bit in more detail?
I can. So we sued, as you know, over 2 things, the First and Fifth Amendments. And in the First Amendment, in regards to the First Amendment, it has had a chilling effect on speech, on my speech, my co-plaintiff's speech, on other journalists that we know who are not part of this case. Combine that with the revelations about the NSA surveillance, you know, this dragnet surveillance, and the unfortunate Clapper case ruling, a case that Chris Hedges was also a part of. And we know that the government has absolute right to target any one of us. It's not that difficult for them to do so. And, you know, combine that as well with this steady assault on whistleblowers. And it's definitely chilling our speech and our freedom of association. We're all worried about who we provide a, quote, platform to, which might be construed as substantial support or being an associated force. And I think that's particularly worrying for people who have worked with or been around WikiLeaks. So
now, the judge in this case ruled that you do not have standing to bring this case up, as I mentioned earlier. So then my question is, who has standing, if anyone, to bring this case up?
So I have a 2-part answer to that. It's a great question. The people who would have standing are the people that we have no way to find. They are indefinitely detained somewhere on this planet. We can't reach them. They have no right to access an attorney or even family members or friends to advocate on their behalf. It's surely happening. People have been indefinitely detained who are innocent. We saw that at Gitmo, and it's probably happening outside of Guantanamo. So. But we're powerless in this instance, just like with Clapper, where the plaintiffs couldn't prove that they were being targeted. They were sort of the targets, de facto targets of surveillance. We can't prove that anyone's indefinitely detained because we have no right to know that. And if you'll recall, last summer, the government attorneys actually refused to assure us in court that the NDAA provision had not been applied since the worldwide injunction, which would have been contempt of court. So really, it's this incredible milieu of where we have no rights, no power, no recourse to find out what's even going on, and then we're denied standing. It's just absurd.
Now, after the Federal Court of Appeals, the next step is the Supreme Court, but they also have the right to not take up this case. In your opinion, does the highest court of the land really stand to take up this case because it is so controversial?
Well, so there are a few other options we have before the Supreme Court. We can file an en banc petition, we would be asking the full 12-judge court in the Second Circuit to hear our case. we can actually go back to Judge Forrest and ask her to clarify a few things, and then we can file a petition to the Supreme Court. You're right, the Supreme Court doesn't have to take the case. We have hopes based on the Supreme Court's very strong stance on First Amendment issues, free speech issues, that they will elect to take the case. It's certainly such a critical a case, and there are so many ambiguities here that the Second Circuit didn't resolve. It would be very surprising if the Supreme Court didn't take the case. It would be pretty rough for me personally, for all of us, if they didn't take the case, because it would be so shocking.
Very interesting. And we know that on our show yesterday, we talked about Congressman Rush Holt, and he's trying to repeal the Patriot Act and parts of the FISA Act as a result of the NSA leaks. It'll be interesting to see if one of these people actually takes up your case in the NDAA and indefinite detention in specific. Tangerine Bolen, founder and director of Revolution Truth and a plaintiff in the NDAA case. Thank you so much for shedding some light on this.
Thank you, Megan.